Hello, everybody, and welcome to History/Law Bite number 274, dated June 12th, 2021. I'm Walter, your mobile historian and blue-collar scholar. This History/Law Bite is entitled Reynolds versus Sims, 377 U.S. 533, 1964. Reynolds versus Sims was the landmark U.S. Supreme Court decision based on the one-man, one-vote principle that required that state legislative districts should be as equal in population as possible. Okay? Reynolds versus Sims is one of the most famous children of the landmark Baker versus Carr decision decided in 1962. So, as we begin all Supreme Court cases, we shall begin as the court itself does. All rise. The Chief Justice and the Associate Justices of the Supreme Court of the United States. Oyez, oyez, oyez. All persons having business before the Honorable, the Supreme Court of the United States are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Please be seated. So let's get into Reynolds versus Sims. So this case began in the early 1960s in the great state of Alabama, when several citizens from Jefferson County, Alabama, including Mr. M.O. Sims, challenged the constitutionality of the Alabama legislature's apportionment practices, okay? Specifically, there were a series of discrepancies among the state's legislative districts, and the state constitution itself required at least one representative per county, okay? And senatorial districts could only have one senator, regardless of the size or the population of the district, okay? Jefferson County, Alabama, contained some 41 times as many people as some other, counties in Alabama, okay? And that, was grossly disproportionate. So whatever senatorial district covered that area, like all of them, according to the Constitution of Alabama, had one senator. So let's say that county in Alabama had, 500,000 people, one senator. Versus another one in Alabama that's only got 1,000 people, one senator. Who do you think is getting the better representation? Obviously, the county with only 1,000 people for that one senator. You don't have to be a active member of a legislative body to understand that when you do represent people, when you only need to cater to the interest of 1,000 people versus 500,000 people, one is quite easier than the other and much more practical. Okay? So this is the type of, discrepancies that you had in the state of Alabama. And Sims would argue that this disproportionate representation, inhibited he and his fellow citizens' ability to effectively participate in state government. Very valid and legitimate claim. All right. So, they filed suit in the U.S. District Court and prevailed, to a significant extent. And the matter eventually found its way to the Supreme Court of the United States, all right? And the issue facing the justices in Reynolds versus Sims, quite simply, was did the state of Alabama's apportionment scheme violate the 14th Amendment's Equal Protection Clause, given how the districts were drawn out and how representatives among them essentially were designed to represent those districts, okay, regardless of the district's population, okay? And the opinion, all right, the Supreme Court As would be expected, and an 8-1 decision would rule in favor of Sims. All right? The opinion of the court, written by Chief Justice Earl Warren, and a decision decided on June 15th, 1964, contained the following essential points. Okay? First and foremost, under the 14th Amendment's Equal Protection Clause, a claim of debasement of the right to vote through malapportionment presents a justiciable controversy, and the Equal Protection Clause provides manageable standards for lower courts to determine the constitutionality of a state legislative apportionment scheme. Okay? Number 2, the Equal Protection Clause requires substantially equal legislative representation for all citizens in a state, regardless of where they reside. That's a very important point. All right? Number 3, the seats in both houses of a bicameral legislature must, under the Equal Protection Clause, be apportioned substantially on a population basis. Okay? Number 4, the federal constitutional requirement that both houses of a state legislature must be apportioned on a population basis means that, as nearly practicable, districts be of equal population, all right, though mechanical exactness was not required, all right? In other words, every single district in the state didn't have to have exactly 32,500 people, all right? If one district had 32,490, it wasn't going to be the end of the world, all right? So they had to be substantially equal in population. In other words, as close as possible, folks, okay? Somewhat more flexibility may be constitutionally permissible for state legislative apportionment than for congressional, all right, districting. This was referring to the court's decision earlier in Westbury versus Sanders, all right? Now, additionally, Warren added that some deviations from a strict equal protection principle are constitutionally permissible in the two houses of a bicameral state legislature where, incident to the effectuation of a rational state policy, so long as the basic standard of equality of population among districts is not significantly departed from. All right? So Warren, reached the end in holding that the district court properly exercised its judicial power here, in this case, by ordering reapportionment of both houses of the Alabama legislature for the purposes of the 1962 elections as a temporary measure by using the best parts of the two proposed plans, okay? Each of which it had found as a whole invalid, and in retaining jurisdiction while deferring a hearing on the issuance of a final injunction to give the reapportioned legislature an opportunity to act effectively. All right? And with that in mind, I'd like to read some of Chief Justice Warren's opinion directly, which I think you'll find very powerful and compelling. All right? Page 562. All right? It says, undoubtedly, the right of suffrage is a fundamental matter in a free and democratic society, especially since the right to exercise the franchise in a free and unimpaired manner is preservative of other basic civil and political rights. Any alleged infringement of the right of citizens to vote must be carefully and meticulously scrutinized. Almost a century ago in Yickwo versus Hopkins in 1886, the court referred to the political franchise of voting as a fundamental political right because it is preservative of all rights. Okay? Legislators represent people, not trees or acres. Legislators are elected by voters, not farms, cities, or economic interests. As long as ours is a representative form of government, and our legislatures are those instruments of government elected directly by and directly representative of the people, the right to elect legislators in a free and unimpaired fashion is a bedrock of our political system. It could hardly be gainsaid that a constitutional claim had been asserted by an allegation that otherwise qualified voters had been entirely prohibited from voting for members of their state legislature. And if a state should provide that the votes of citizens in one part of the state should be given 2 times, or 5 times, or 10 times the weight of votes of citizens in another part of the state, it could hardly be contended that the right to vote of those residing in the disfavored areas had not been effectively diluted. Okay? It would appear extraordinary to suggest that a state could be constitutionally permitted to enact a law providing that certain of the state's voters could vote 2, 5, or 10 times for their legislative representatives, while voters living elsewhere could only vote once. And it is inconceivable that a state law to the effect that, in counting votes for legislators, the votes of citizens in one part of the state will be multiplied by 2, 5, or 10, while the votes of persons in another area would be counted only at face value, would be constitutionally sustainable. All right? So Chief Justice Warren is, obviously outlining the importance of the right to vote and for individuals to have their vote counted equally and for everyone's vote to have the same weight, ladies and gentlemen. Not voters here having essentially a useless vote, whereas voters over there having an almighty and limitless, authority with their vote. All right, that's not the way it is supposed to work under our American scheme of government. Everybody's vote is supposed to count the same way. His vote is not supposed to weigh more than mine. Her vote is not supposed to weigh more than his. Everybody's kumbaya vote means the same thing. All right? And that is what this decision helped to emphasize with respect to state legislative redistricting and ensuring that all districts are as close in population as practicable and possible. All right? So, judgment of the Supreme Court of the United States in this case was to affirm the decision of the district court and remand it back there for further proceedings. All right? Now, everyone didn't agree with Chief Justice Warren's very wonderfully written opinion here. Justice John Marshall Harlan II, a frequent dissenter in Warren Court decisions, argued that the majority opinion in this case had ignored the language, intent, and the history of the Equal Protection Clause of the 14th Amendment. And the court, in doing this, in requiring the states to engage in such a massive redesigning project of their legislative districts, the court was essentially amending the U.S. Constitution via judicial decision. Harlan predicted doom from this, doom that has not occurred. All right? Justice Potter Stewart also authored a concurrence here. Justice Stewart agreed with the majority opinion that the malapportionment here was serious, all right, very undemocratic. But he wanted to emphasize, kind of like moving along, Harlan's position just a tad bit, that it was not the court's place to provide any guideline beyond general reasonableness for apportionment of districts. In other words, let the states figure out, how they're going to draw their districts, as long as there's reasonableness in the population, as close to equal population as possible. How the states would do that, that's on them. It's not for the court to tell them out piece by piece how to do that. All right. So Reynolds versus Sims, indeed, as has been described by many individuals in the legal profession, as well as many individuals in the political world, as one of the most far-reaching decisions the Supreme Court has ever given. All right. And many have argued that it has made America a more democratic country altogether in ensuring that all citizens have an equally weighed vote when they cast a ballot, okay? So that the citizens in one part of a state do not arguably mean more than another, all right? His votes do not mean more than mine. Their votes do not mean more than ours, okay? And our country with it, all right, has become fairer and more equal, all right, as the court wanted to emphasize with the one man, one vote principle, all right, in requiring that with state legislative districting, all right. So to further add some of the effects of this decision, state legislative districts, folks, should have no more than a 10% disparity in population, no matter how many legislative districts a state has, all right? But there is flexibility. That's not a hard line. That's not a do or die number, okay? Greater disparities may be allowed in some circumstances, with compelling reasons, okay? And smaller disparities, have often been struck down, because the reason wasn't good enough, all right? So that 10%, all right, is a goal, but it's not, an electrified fence, all right? It all depends on the state, and it all depends on what they've got going on. But generally, no matter what you've got going on, all of the state's legislative districts, according to this decision, should be as close to the same population as possible, all right? And once again, reiterating the holding of the court here is that the 14th Amendment's Equal Protection Clause requires, ladies and gentlemen, that state legislative districts should be comprised of districts that are as equal in population as possible. All right. It is the duty of the state to ensure that all of its legislative districts have roughly the same population. All right. The court emphasized that the population did not have to be 100% the same. Okay. There's flexibility. There could be differences, but the state has the obligation to make sure that those districts are as close to the same population as possible, all right, or as Warren put, as practicable, all right? So that is the holding in Reynolds versus Sims. 14th Amendment's Equal Protection Clause requires that state legislative districts be as equal in population as possible, all right? So, any questions or controversies, leave them down below and I'll be happy to answer them. If you enjoyed this video, learned a thing or two from it, please drop me a like. I would greatly appreciate it. And if you have not subscribed to my YouTube channel, please do so now. Your support means more than you will ever know. All right? So take care, stay safe out there, and I will talk to you at the next video. Peace.